So we're going to get started with our next session. Thanks everyone for making your way back in. So this panel is going to focus on something that Sam hinted for us in his remarks, addressing hiring discrimination against older and disabled workers and former incarcerated individuals. Our speakers for the panel will be Craig Lean of K&L Gates, formerly with the OFCCP, and Marjorie Messidor, plaintiff side lawyer with Phillips and Associates.
Hello.
And the commentators will be Troy Kessler of Kessler Matura and James Philbin of Philbin Law Firm. So, folks, take it away.
All right. Good morning. So thank you for having us. So we're going to be talking today about three areas or three groups of workers who are tremendously underutilized in the workforce, and we're going to talk about that. We're going to talk about these three areas as well. Workers are particularly subject to stereotypes and stigma associated with older workers, disabled workers, and previously incarcerated workers. And maybe just at the outset, Craig, if you can just share with us your thoughts. I've noticed many DEI programs out there leave these three categories of workers out. And I'm just wondering in your practice if my thought on that is consistent with yours and if you've had some solutions to that.
Thank you, Troy. It's a true honor to be here today with this distinguished panel and talking about a really important topic. You're 100% correct. When I was at OFCCP, we saw a lot of affirmative action programs, obviously, and now in my practice on the management side, I advise companies on their DIA programs. Often they're D&I or DEI programs. A lot of them don't even include the A for accessibility. But I have to say that very, very few include disability. None that I've seen include age, and none that I've seen include incarcerated individuals. I know that there's a stat I've seen from the Harvard Business Review that says about 4% of DEI programs include disability. And I assume it's less for the other two groups. So, most DEI programs or DIA programs include race and gender, and a lot of them don't go beyond that. The more advanced ones will often include intersectionality between race and gender, but again, often don't include the other groups. It's important to include the other groups. That's obviously part of inclusion and part of diversity, but it also ensures that those individuals in those groups recognize that they belong at that company and that they're going to be supported and that they can be part of the DEIA program. It makes it much more inclusive.
Yeah, and Marjorie, I'm just wondering from your perspective, representing employees, particularly during the course of litigation when you've analyzed DEI programs, have you noticed, similarly to Craig, that many of them have left out older workers, disabled workers, and workers who were previously incarcerated?
No, absolutely. And it still becomes the case that from a litigation perspective, when we are looking at cases that deal with any sort of level of employment discrimination, the easier cases to litigate are what we would consider like the low-hanging fruit. Things where you can clearly identify an animus, hostile work environment or something like that. But what is unique about this particular group of individuals, older workers, previously incarcerated and disabled, is that rarely is an animus identified. There isn't, there aren't a lot of hostile work environment and, comments about people who have a disability. Usually people are not that cruel or obvious in their intention in that regard. A lot of it is usually miseducation, misapplication of the law, as well as trying to balance business need with their understanding as an organization of what their obligations are. So as a result, when DEI became more of a centered topic, when everybody was talking about making the workplace more equitable and more inclusive, the target was to try to, first of all, minimize any unconscious bias, try to eradicate the obvious bias, and that has been the focus. And that's a good thing, but what has happened is that there are these entire other groups of individuals who have left seemingly without protections because of the way that the discrimination shows itself in the ordinary course of the workplace.
And I would add to that, I would ask employers to take another look at their DEI programs because there is a lot of unconscious bias towards people with disabilities and toward older workers and toward formerly incarcerated workers. For people with disabilities, you know, and you were touching on this about sometimes businesses don't fully accommodate, and that is a form of disability discrimination, and that may be the most common. But you know, the idea that people with disabilities can't perform certain jobs or are limited in their ability to perform those jobs because of their disability is a stereotype. There are occasionally, you know, there are disabilities which will impact the job. And if an accommodation can allow that person to perform the requirements of the job, you grant them the accommodation, and then they go ahead and you know, that's helpful. But there can still be ideas about stigma related to, for example, autism, ADHD, a variety of different non-apparent disabilities, stigmas related to you know, more traditional, in the disability world, the physical disabilities, which are often the focus of regulations by DOJ, access. You know, a lot of times, like you mentioned, you may think that people are not going to be cruel to discriminate against that group, but you know, there's still stigmas that are there, like, oh, well, this person is in a wheelchair, so they cannot do X. That's often not true. Same with people who are blind or low vision. They can often do everything that anyone else can do as long as you have that accommodation. And in fact, the resilience related to their disability often makes them even a higher level performer. So, you know, addressing these stigmas are extraordinarily important for both apparent and non-apparent disabilities.
Well, you know, speaking on behalf of older workers, in my observation of this, I mean, obviously I've seen significant amounts of litigation based on behavior in the workplace with existing employees. But I think it's very difficult just in the application process for these individuals who may be being discriminated against to identify that that's happened and then to actually do something about it. Most people that don't get a job are moving on and trying to find another job rather than thinking that I'm going to take some legal action against the company because I think, based on mostly innuendo, that it was based on one of these protected categories. So what are you seeing on both ends with respect to that kind of activity?
Yeah. So as it relates to a lot of the more frequent scenarios in which we see that this comes up are in failure to hire, failure to promote, type of cases, and unfortunately it becomes it's an uphill battle to litigate because most of the discovery is in the hands of the employer. So unless you have an interview where somebody actually says something, or you see them write something on the resume, or something that gives you a clue that, you know, that but for standard, that but for their age, but for their disability, they otherwise were excited or were ready to hire them, then it becomes an uphill battle. Not so much with the previously incarcerated, just because the process is a little bit more formulaic post the last chance, in that they have to receive the offer before a background check is even done, and they also do not have to disclose their former incarceration prior to an offer being extended. So it's easier from a fact perspective, right, when you're litigating to for those types of cases than it is for any of the traditional failure to promote, failure to hire, or even disparate treatment cases.
And then I would add that, you know, these are three areas where you have a higher unemployment rate and a lower labor force participation rate, which are both good signs. Good may not be the right word. Both are signs of discrimination, I would say, you know, systemically in society. So, you know, for disability, the unemployment rate is typically double the general unemployment rate. Labor force participation has been around 20% for years. It's gone up during the pandemic because of the availability of remote work and telework, which is something I would, when employers are, and I know many employers are quick to want to get back, everyone get back to the workplace, but think about your workers with disabilities and see if you can still accommodate them. And because the increase in labor force participation is really wonderful in that area, but it's still a very low labor force participation. For older workers, the unemployment rate is even higher. It's about double the disability employment rate. It's like, I think, something like 4 to 5 times higher than the general unemployment rate. And then for incarcerated workers, it's extraordinarily high. I read something to the effect of 60% of incarcerated workers have a real hard time finding a job at all. So, these are areas where whenever you see a higher unemployment rate for a particular group, you have to assume that there is discrimination occurring in some way, either unconsciously or consciously, that would lead to this much higher unemployment rate. So these are all points that we need to consider systemically as businesses. And then the last point I would make, and we've talked a little bit about cases and avoiding discrimination, but there's a real strong business case for employing these groups. We have a very tight labor market. These are underutilized parts of our workforce, and there's a lot of skilled labor there. So a DEI program that's forward-looking that includes these groups can be very helpful for businesses, in addition to decreasing the risk of discrimination claims, because as you show that your DEIA program includes these groups, and you have maybe affinity groups or employee resource groups composed of these individuals, and you're adopting policies that are proactive towards these groups, you're going to be able to have a stronger defense that you're not committing disparate treatment, that you don't have animus, that in fact you care about these groups of individuals, and you will hopefully avoid lawsuits.
Those are interesting points, and I just want to make a point about age discrimination in particular. Right now, according to recent statistics, the older worker, meaning 75 and older workers, will be doubling almost in the next 10 years. So the participation rate amongst older workers is increasing tremendously. As at the same time, these DEI programs really haven't taken them into account yet. The other point I want to make is that part of the difficulty of litigating cases on behalf of older workers, especially with respect to federal claims, is that the burden of proof is so high. Right now, we operate under the but-for standard. So but for the plaintiff's age, she would have remained employed. I mean, that's the typical standard. There is some talk I just want to highlight for everyone. It is, I think in the materials, there's a bipartisan bill to change the standard back to the mixed motive standard. So my hope is that by the time we're here next year and we're talking perhaps again about these issues, that there will be some progress. There was just a hearing on this about 3 weeks ago, and there does seem to be a consensus building that the but-for standard is not what was intended. Go ahead, Craig.
I want to hear what you had to say about it, because it's more of a plaintiff side issue, I would think. But I will say this, and I know I'm on management side, but I was the OFCCP director. And I will say that it's interesting to me, for example, that the executive order for OFCCP does not include age. It's interesting to me that the higher standard, the but-for standard, applies to older workers and workers with disabilities, but not to other groups. And that's something that as a society we need to reflect on. We need to reflect on that, because those groups are important too, and should not experience discrimination. And we should generally have a similar approach, I think, to discrimination in society, that it's wrong and needs to be eliminated.
And to your point, this is where I say the awareness, the level of awareness comes in. I think that as a society, we are largely ignorant to how someone with disabilities functions throughout daily life and what they can or cannot do. We think we know, but we don't. The kind of arguments that sometimes, and I say ignorant not in a, I know it's a harsh word, right? But we don't know, right? What it takes or doesn't take for somebody with a disability to do their job. And we presume. It's sometimes shocking, the commentary and the things that people say on both sides of the aisle about people with disabilities, of what they think they can or cannot do. And it's even more shocking when we talk about things like mental illness or anything having to do with disabilities that are not necessarily physical, right? So where I think we have done a very good job when it comes to discrimination on the basis of race and gender, largely bringing awareness, right? We had, the reckoning that came post George Floyd. We had the Me Too that really brought a lot of daily conversation, dinner table conversation around these issues, perhaps in demographics that maybe took for granted that these were even things that remain to be such large and impactful issues. But I have not seen that same level of reckoning in these groups, and it shows, because what society does is cues the legislation, et cetera, and then it creeps into the workplace. This is also my pitch as to why everybody, if they get an opportunity to be a juror on a jury, should always do everything that they can to do their civic duty, because, a lot of the common sense things that we see in the workplace hasn't yet reached the bar, or so to speak, or the law to be equally addressed. And I think that's largely why in the executive orders and the like that we don't see it, because you know the term that the squeaky wheel is the one that gets the oil, right? So where's the squeaky wheel regarding these demographics as well?
And if I could add to that, I think law firms in particular need to take a look at this. In the disability space, the NALP statistics indicate that, and this is not an accurate statistic in my opinion, but it says only about 1% of law firm attorneys and partners have a disability, when most likely it's much higher, like society in general. About 20 to 25% of people have a disability in the United States, and most people will have a disability at some point in their life. And I also read a statistic that said that among lawyers, the disabilities such as anxiety or depression can be even a majority of attorneys at some point can have that disability or that condition. And yet you see self-reporting of 1%, which also makes me think that many people that are lawyers probably are not seeking accommodations for those disabilities, may not be seeking treatment. And it's well known that there is a higher rate of suicide, sadly, among attorneys. So these are issues that law firms need to think about.
Right.
And encourage people to self-identify, seek accommodations, get supports. And you know what? It applies also in the area of older workers. A lot of law firms have mandatory retirement ages. There's pressure on lawyers to leave the firm or to give up their work to younger attorneys. And I support succession planning and helping younger attorneys to do better. But we do need to value our older attorneys too, and law firms need to set the example in these areas.
If we can just turn to the accommodation process. I mean, I think that has changed tremendously for many of us, especially representing white-collar employees with the advent of remote work. And I'm just curious, Marjorie, from your perspective, what has changed in sort of your evaluation of these cases and counseling clients?
So here's what has changed and here's what has not. What has not changed is that Second Circuit opinion that says that remote work is not considered a reasonable accommodation. That has not changed yet, but we're waiting any day now, right? That it soon will change. What we've been able to do is make creative arguments saying that it was a term and condition of employment. It was a bargain for exchange during the course of the hiring process, where you advertised this as a hybrid position. My client knew they required a hybrid position. They came into that position, and then 6 months in, you decided that you were going to bring everybody back to the Park Avenue office, and now the term and condition of employment has changed, and now they're telling you they need an accommodation, and you say that you can't accommodate them because there's a business need for us to be able to look at each other in the eye. I know I'm oversimplifying the issue. And I say that to say that this is where, creative lawyering and really understand the facts specific of the individual jobs and then dynamics really comes into play. The conversation that I have with an individual who is, for example, an attorney who had a hybrid work schedule, was largely been working remote for the past 2 or 3 years, is a very different conversation that I have somebody who directs maybe a sales team or an advertising team, which there may be a different impact. We still don't know how courts are starting to treat this. Largely, and I know this because this just happened maybe 2 weeks ago, a judge says controlling law still states. That Second Circuit case still says that remote work is not a reasonable accommodation. And I said, so then you have to start talking about how did the terms and conditions change, and analyze it under a different different analysis altogether. With that being said, I think that if you're able to get past motions to dismiss and summary judgment, if you put it before a jury, we'll start to see a tide change. Because because again of the awareness of how going remote was a lot maybe easier than what people had anticipated. Before that, it was never heard of. What do you mean work from home? Right? And how much easier it is now. It's going to be harder to say that it's not a reasonable accommodation, at least as it relates to the standard in accommodating a disability. Now, where it gets very tricky is when you have disabilities that are related again to either mental illness or anxiety and depression, because then people almost can be very dismissive. Well, I have high anxiety and therefore I need to work remote because, getting on public transportation causes me anxiety. And then you get, an eye roll and a wink on the other side, like, oh yeah, well, being on the subway stresses me out too. And that's not the standard. And this is where I say, what we are experiencing as a society in the everyday workplace has to meet awareness and recognition and understanding of what is needed in order for people to perform and thrive at their best in their workplace.
And then from my perspective, from the management side, I would say that the concept in the ADA that the employer controls the terms of employment, and one of those could be coming into work, is an important one for employers. I don't want to de-emphasize that. Having said that, I would indicate, what I advise employers is that they should be open to remote work. I mean, that's definitely the future. Sooner or later, it'll be an act of Congress, I assume, or maybe an action of the EOC or OFCCP for federal contractors. But, remote work is here to stay, and most companies now are at least allowing some of their workers to remote work. And once you start allowing some workers to remote work, you have to treat your individuals with disabilities at least as well. And so it seems to me that it's better to embrace remote work for people with disabilities. It will open up labor markets that weren't there before for many companies, and it definitely helps with increasing disability recruiting, meeting your disability self-ID goal of 7% if you're a federal contractor. So it just seems to me that that's something that contractors should embrace. And even on the management side, I would advise that to companies, that they don't get in battles over whether they should grant a remote work accommodation to someone with a disability. Who needs it?
Yeah, and just a practice point or a litigation point, one of the things Marjorie and I one of the secrets we'll share with you today that we're always looking for is when an employer makes a unilateral determination that all employees must return, no exceptions. That's a case.
Yes,
right? And,
automatically.
That's Twitter.
And well, I'm not going to comment on which employer may have done that, but I would say we see it a lot, and I think in our respective practices, especially with the push to get folks back to work and in person, I think many employers have made the mistake of kind of disregarding the accommodation process and the fact that it must be individualized and particularized for every employee who's requesting one.
And then,
Go ahead, Jim. Yep.
No, but the vast majority of employees without disabilities, don't have that same argument, correct?
Correct. So there has to be a disability that would trigger
Right.
the accommodation process. But I guess my point would be, anytime an employer makes a unilateral imposition on their entire workforce and says something like, no exceptions, everyone must be in the office, 4 days a week, no exceptions.
Right.
That is a sign that that employer is not handling the accommodation process correctly. But of course, the employee making the request has to actually have a disability. Right.
Right, which they've had to declare, right?
Well, I mean, now we're going to get into the weeds a little bit with New York State and New York City law, but I don't actually think the employee actually has to go to the employer and say, hey, I have a disability, I want an accommodation, right? I mean, if the employer knew or should have known that there's a reason to start the interactive process, I mean, certainly in the first and second department, there's good case law on that issue, that the employer cannot just ignore what they see going on with the employee in front of them.
But going back to the application process, so I come to you and I say, I applied for a job and I didn't get it, I think, and they hired somebody younger. That's all I've got. How do you approach?
Okay, what was the job that you applied for? I know, let's do this, right? What was the job?
Let's say it's just from the workplaces that I work with, let's just say I'm a operations manager at a logistics company.
And was this an internal, were you already working there and this was for a promotion? Or
No.
this was an outside?
Outside.
Outside. And how do you know that the individual that was hired for the position is younger?
Because I was told by a friend of mine that works at the company that that's who they hired.
So tell me a little bit about the interview process. How did that go for you?
They reviewed my resume. I have extensive experience in this area. I've been doing it for 35 years. And they seem to be very impressed with my resume during our discussions.
During the course of your discussions, did they make any commentary to you other than your qualifications that made you believe that your age was a consideration at all?
There was one comment that he said, well, it seems like you've been around the horn here. Now I'm helping her.
And in response to that, what did you say?
I laughed.
Okay. Did they say anything else?
No.
And the individual who ultimately got the job, do they have the same level of degree of education as you do?
Yes.
And what about experience?
Well, lesser, only because of time.
Okay. So here's what I would say. I think that when you are in a workplace dynamic and your instincts tell you that there's something amiss here, that you should trust that instinct. However, unfortunately, trusting that instinct and being able to prove it as a matter of law are two very different things. So what I would say to you is, although I believe that what your experience may be true, that there may have been age discrimination afoot here, we wouldn't be able to assist you in this regard because we would not be able to meet that higher bar. However, if you feel very strongly that age discrimination was here, I would highly suggest that you go to the EEOC, here's the website, file a complaint so that the matter can be investigated, and perhaps through that EEOC process, you might be able to get information that would further give you additional evidence to your original gut instinct. If they don't have anything, it costs you nothing. But if they do, and they find something that, where we see there's smoke, there may be a little bit of fire, come back to us with what you have, and we'll see how you can help you from there.
It's not our first day. But Craig, with respect to the same issue as the EEOC would likely or possibly look into is, what is your record of hiring across your population? So are you advising employers that they need to look at those statistics in
I
their
do.
hiring process?
Certainly for reductions in force, we ask that they do an adverse impact analysis based on age. For hiring, it's definitely a best practice. Most companies now will look at hiring at least qualitatively, but sometimes quantitatively, based on race and gender to see if there's adverse impact. But age can be looked at as well. There's some more complexity because you have to determine what are the comparator groups. Is it 40 and under and over 40, or do you do it in like 60, 50 to 60, 40 to 50? There's different ways to look at it, but I advise it because I do think you want to know. You always want to know if there's adverse impact going on and see if there's a reason for it. I mean, that's definitely a best practice in the area. And then I also wanted to mention regarding incarcerated individuals. It is very important that companies are looking at the green factors that the EOC mentions. I do advise a lot of companies related to this issue, and a lot of times they don't really have a policy in place which incorporates the green factors, which basically is whenever you're looking at a formerly incarcerated individual and you're looking at what's happened. One, it needs to be an actual conviction, can't be an arrest. So it needs to be a conviction. Two, you need to look at how long ago was the conviction, the severity of the conviction and what it was for. And then lastly, what is the job? Like you mentioned, when even asking about age discrimination, what is the job? What was the job description? Did this particular conviction relate to that in some way? So, these are all, so I guess my general answer to you is yes, I would like to see employers have in place in advance, not just in response to a claim, but an auditing process where they're looking at age discrimination and discrimination against these other groups in a systemic way.
Yeah, Marjorie, and maybe we can turn to the rights of the previously incarcerated. We haven't spoken about them much yet during this panel. Marjorie wrote an excellent article. It's contained in our materials that really summarizes the state of New York law, but maybe for the benefit of folks here who may not have that much experience with it, can you just summarize what the process is, and perhaps to the extent it may differ from what Craig outlined with the green factors, maybe highlight that as well?
Sure. So depending on whether the employer is located in New York City or in New York State, it is usually a general requirement that an offer must first be extended before the question can even be asked whether or not the person has been convicted of usually a felony. Misdemeanors are all but stricken to answer that question after an offer has been extended and then a background check to be done. And if the offer then is rescinded as a result of the information that was given in the background check, you have to give the applicant an opportunity to basically rehab their application and include some of the green factors that have already been widely discussed so that they can give you the particulars. You need to ask the particulars of the particular conviction, the facts about it, how long ago it was, and also you have to also be able to align it with some of the duties and responsibilities of the particular job that they are applying for, okay, to even use the background, the failure to pass a background check as part of the reason why you are not hiring the individual. There are two major exceptions that people should be aware of. Number one is law enforcement. Unless somebody has a certificate of relief from civil disabilities, usually the green factors do not apply in those circumstances. And also for certain banking-related positions. I forget the name of the statute off the top of my head that has a clear bar of not hiring certain individuals with specific convictions, regardless of how long ago it was, et cetera. And usually, I would say 9 times out of 10, the employer has not engaged in any sort of level of discussion. It's usually, well, we found that you had this conviction, so sorry, we're not gonna hire you, and it's a done deal. Those are cases that are generally very easy to prove because a lot of the communication is most all in writing. They give you the background check. They actually say, we are not hiring you because of this. So it makes it very, very easy from a proof perspective. Where we find that a lot of applicants and potential plaintiffs are finding difficulty is getting attorneys based on their own unconscious bias to take on these cases and to pursue the rights for them. And these are individuals who may have had a murder conviction 25 years ago, a sexual assault conviction 30 years ago, who are finding it because of the particular heinousness of the conviction or the crime that there's just not a population that may be willing to assist. And these are individuals who go on from job to job to job, unable to find anyone to help to avail them of their rights.
But is people that have committed violent crimes, is that ever a basis for not hiring for most positions?
No, not blanketly if it
Right.
is more than 10 years old, and not blanketly depending on the level of the job that the person has. Like, for example, if somebody's applying to be a cashier at Burger King, the fact that they had a murder rap 30 years ago was of no consequence. Now, if they're applying to be a cable installer going into people's homes and they have a violent conviction, that is a different analysis. Then, again, these factors, they just add weight. They're not necessarily things that cancel out. It may be a circumstance, if you have a murder conviction 30 years ago, you may be able to install cable in somebody's home and it not be an exclusive factor. But, again, these are things that have to be weighed. Where we find that most employers fail to meet the standard is they have not even engaged in the analysis.
Yes, that's what
They
I
have
was
failed to even engage in the analysis, have the discussion. It is almost like, listen, and I don't want to get on my soapbox here. Everybody has a chapter in their life that they don't want read out loud, right? At a certain point, there has to be a rehab for us to be able to contribute something to society. None of us is without worth or value. And even from a human perspective, if we just engaged in the process to say this was given due consideration, and when we weighed these factors and we decided as a business purpose this was too high of a risk for us, that will knock out 60% of litigation. Because most of the time when I'm writing these demand letters or these draft complaints, it literally is, you have a murder charge from 30 years ago, so sorry. Meanwhile, this individual may be 60 years old now, right? And when they did this, they were 18. Things like that. I mean, don't get me wrong, murder is murder, but at the same time, the level of analysis is so abysmal, it makes it very easy from a proof point to be able to show that there was a deficiency in the process.
If I may add something, I have the exact same view as you do on this. When these issues come up from the management side, it's often that the analysis hasn't been done. It's almost a statement like, well, this person did this. And what this is often very bad. But you're not part of the punishment process. The person has gone through their statutorily prescribed punishment. They've hopefully been rehabilitated. They have a right to try to get a job like anyone else and make a living for themselves and their family. And it needs to be job related, what you're talking about. If that increases a risk, an actual risk, not a hypothetical risk, to your workforce or to your customers, then that's something you can consider. I would say it would be, one issue I've always seen here, I'm curious for your thoughts on it too, is, I think a lot of companies think about, well, am I committing negligent hiring or negligent retention by having this person here? So let's say I do the right thing and hire them. Down the line, if this person does do something, will I be on notice, and will the court say, well, hey, you know what? All those great things that you said you did in trying to hire more people who have been incarcerated, well, we're going to throw that outside now, and we're going to focus on the fact that you hired a formerly convicted felon who committed the same offense again to one of your customers or to the co-employee. It would be helpful if there were safe harbors, I would say, in these laws, because employers are right to be concerned about that, but you can only be so concerned. I would say the bigger liability risk at this point, if you're just going to look at it from a liability perspective, is having a blanket policy that you're not going to consider that person.
Right.
But at the same time, I would say ultimately, it is in your interest to be open to hiring formerly incarcerated individuals as long as you go through the risk analysis with the advice of counsel and have a policy in place.
The other thing also is that when we're doing a negligent hiring analysis, you really have to show that the person there was some sort of, dereliction of duty, right? That they failed to behave reasonably with the information that they had. If they can show as a matter of law that they assessed all of the factors and everything showed that this would be low risk, I would say that an action for negligent hiring would have an uphill battle in succeeding if they were able to show that this was a very thoughtful, and very, well-documented process in hiring this individual. I know that recidivism is real, right? But if you're showing that the risk here was so low that it was either the same to someone who was not previously incarcerated or versus somebody that he was not, I would say that, that's on the defense side, that would be a case that I would be comfortable, processing through. Now, there's the legal side of it and there are the optics, right? No, I'm sure Optimum does not want a headline saying, former, convicted felon, commits other felony in Optimum customer's home. That would be a PR nightmare. I get that. But I think that the higher risk, as you've already indicated, would be that previously incarcerated individual bringing a case against Optimum saying that they were not even considered is much higher than the former happening.
Yeah, and maybe just to clear up a misconception, if we can, Marjorie, when we're talking about convictions right now, but what about arrests or charges? Is that subject to the same analysis, or is it different?
It's a different analysis. Under the New York City human rights law is the only one that gives any recognition for as a protected category in terms of an arrest. It's not considered a protected category under the state human rights law, and certainly not under the federal. I always say an arrest is an accusation, but even if you are arrested and you are in a current job, that could be a reason for you to be terminated. So unfortunately, unless of course you're in New York City and you have this additional protection, but it's not given the same accord. It's not given the same level of analysis. It's a lot easier to be the subject of an adverse employment action based on an arrest than it is a conviction.
Yeah, I mean, I've always found that to be a strange concept, right? That you actually have more rights actually as an employee if you've been subject to a conviction versus just an arrest, right?
Correct. I have seen people try to get rehired after an arrest has been cleared, like after they've been acquitted, and the like, and that then gives them the protection. The fact that they've been accused of the crime and acquitted, and that is now being used against them not to rehire them, that is actually a stronger case
Right.
than when they were. I don't know. It's as my children say, make it make sense. It just doesn't.
I would say that
Yeah.
OFCCP has a directive on this, on convictions and, touches on arrests. But, from a pure EEO standpoint, disparate impact, I would not consider arrests if I were you. If you make a decision solely based on an arrest, it's not going to satisfy the green factors generally. And, for OFCCP's perspective, if it is part of a disparate impact, you're going to have a hard time justifying it.
Yes.
Now, if it's something that's clear that the person did and it's a prior act that relates to it, that comes up in their background check, you might be able to consider it for that purpose. But I wouldn't consider the arrest alone.
Right. The other thing is that, yes, an arrest is only an accusation, but do you know how easy it is to get arrested? I mean, it is quite very, very, very easy. I mean, I can say, Jim came in here with a gun and call the police right now, and depending on the exact circumstances that, it really is such a low bar.
And in this country, there is a huge disparate impact based on
Correct.
historic discrimination
I
and
had
other
a-
areas of arrest. So, I mean, we need to keep that in mind. If you're really committed to DIA, I wouldn't consider
Yes.
arrest.
Well, just interesting, I had a case when I was at Maersk, and we had a manager, we were selling a chassis company, and he was meeting with investors to try to sell the company, and at the same time, he was in a conspiracy to smuggle drugs through the containers in the port. So he got arrested with 3 other longshoremen and a container full of cocaine. We fired him based on absenteeism.
So on that note, we'll wait for the Netflix series on that. Thank you to this great panel.
Thank you.